You are already, I think. I would like to welcome you to our webinar on oil and gas. As a DAC, we are pleased to organize such an event together with Azerbaijan Arbitration and Mediation Center. Our distinguished speakers are here. I will introduce them before their presentations. Without wasting any more time, I would like to introduce our first speaker, Mr. Serhat Eskiyoruk. Dr. Eskiyoruk is an academic at Adana BTU Faculty of Social Sciences and a research fellow at Ministry of Energy Legal Department. He is also one of the arbitrators of EDAC. His presentation is about Iraq legal system. Please, Mr. Serhat Eskiyoruk.
Bir mən təqdim edəcəm. Birinci özünkiləri təqdim elədi. Baxın bir şeydir.
Vera, please switch the microphone. Okay, sorry. Because with some interpreter services, but without the, okay, outside the interpretation. Thank you.
Mr. Eskiyoruk, you are on mute.
Oh, I'm sorry, I just couldn't hear you. Please send my regards and apologies. Good afternoon to everybody. It's my pleasure and honor to be in this symposium organized by EDAC and Azerbaijan Arbitration Institution. And it's very great to have colleagues and brothers and sisters from Azerbaijan with this event. My presentation, as Dr. Gökte mentions, about the complexity of legislative framework of oil and gas law in Iraq and the conflict of authority between the central government and the Kurdish regional government about the national resources in northern of Iraq. I will focus on the oil and gas law of in Iraq and also effect of its impact about the resources and the authority of the Kurdish region in north. I have a little PowerPoint. So, as I mentioned, I will discuss about the oil and gas law. My structure I will make introduction about that, and later on I will mention the sources of law in Iraq and also in Kurdish region. I will mention the legal structure pre-2003 and after also 2003, the invasion, and what is the situation of the revenue distribution mentioned in the documents. But there is a federal law and regional law that make a distinction about that. I will then mention the 2005 Constitution about the articles about this distribution and authority, and also this last month decision by the Supreme Court of Iraq about the issue, and also its implications, possible implications. I will try to interpret. So, as an introduction, I will say the oil is very important for Iraq, and it's almost 90% of its income of all countries, and also this is also about more than 90% of the northern part of that. Iraq oil they are the second in OPEC as a producer, and also the potential to be largest. But there is a issue of conflict between the central and the regional government. Why? Because now it's a federal system, and I will just mention the position of that. When we look at their legislations, we see that there is a federal law, but it is not stalled, it's not into effect. It was drafted in 2007, amended in 2011, but couldn't pass, didn't pass. So by that time, KRG, Kurdish Regional Government, passed its own legislations. and also the authority gives them to make them executive, legislative, and juridical powers. So based on that, they make their own legislations, including the oil and gas law. And there's this ongoing dispute between them, between the regional and the central government. When we look at the constitution, we see it's a federalism. It is the 18 governors and regions, and also specifically mention the semi-autonomous Kurdish region in the north. When we look at the structures, legal framework, we see that it is based on Ottoman law and French and Egyptian and also Islamic law. It's a blend of that, I can say, in a way, from my research shows. And also they mentioned to customs and uses, so also Islamic Sharia law might also influence in some decisions. They also mentioned in civil code, and also Article 2 of the Constitution also makes them some kind of Islamic principles. So there's also influence for Islamic law as well. As I mentioned, prior to 2003, there has been constitutions. There was important legislations passed in 60s and ongoing about expropriation, nationalizations of the oils, and also continuing structure of the organization of oil marketing and oil exploitation and production and sale rights. And after 70s, there was constitution, and until 2005, the new constitution was passed. How was that period? We may remember in 2005, there was a deadline about the passing of constitution. So before 15th of October, there should be a referendum and the constitution should be passed. So there are some issues, seems that little vague in various clauses in the constitution. What about the revenue distribution? They say they discuss in different authorities about almost 17% should go to the northern side. And the constitution also makes reference to all people and the distribution of oil and gas revenues to the people of all Iraqi people. From the federal law perspective, as I mentioned, there was a federal law, but it couldn't pass. So there is a deadlock, political deadlock in this draft legislation. So the KRG passed its own hydrocarbon law, and since then there were over 40 production sharing agreements and 14 service contracts by the KRG and also the federal government. So there are different contracts, and I will also mention some clauses, like what are the clauses in dispute resolution clauses. I look at KRG's website. Not all contracts are shared, but I can say dispute resolution is normally the mediation first, arbitration later on. Mainly they mention English law and LCA mediation and arbitration, I could see. And I can say it's very usual to mention an arbitration clause in KRG's contract. What is the dispute comes from? Dispute comes from the 2005 constitution, I can say, and also it's also argument based on the KRG's argument that in the north we have the authority, and according to our law we can produce and export oil and gas, mainly via Turkey, the pipelines. So they based on the article 111, it says oil and gas are owned by all Iraqi people. And in this article, which is contrary to research various producing countries, there is no reference sole management about management of this oil and gas. Instead, in the following article, it says all management is from all central and all other counties and parts of the states will make the whole co-management, it mentions. And Enerji also mentions 112 article, which is fair and proportional distribution of revenues. And they had a discussion because the central government halted their share, they argue that. So that is why I, based on this article, as well as the legal right of general principles of seizure of rights, they argue that they have the authority to making these contracts and getting benefit from them. And also continue with the second paragraph of the same article, which also makes again to the people of Iraqi, not the central government.
Just one moment, please. I am connecting with Dr. Eskiörük.
I'm sorry, I just dropped, I think. I'm sorry. So, which is contrary to the usual way of the constitutions in the normal federal governments. If there's a conflict between the federal law and the regional law, normally federal laws supersede, but in this Iraqi case, it's vice versa. It says the federal provisions and regional provisions is prior over federal law. But 121 makes that it is if it is outside the exclusive authority. So the Kurdish part says it doesn't makes exclusively the authority of the central government. So there's argument. So what happened since then? Enerji makes autonomous de facto contracts, agreements based on these revenues and based on these articles of the constitution, and also makes its constitution and all regional laws there has been a very long discussion about that, and last month there was a Supreme Court gave a decisions about in couple of cases come together, and then they say Enerji's regional law is unconstitutional. So it is a big news for and also long-awaited decisions by the Supreme Court. But indeed, also the decision has some gaps, I can say, or some not clarify some issues. It says Enerji should hand over the production, but it doesn't cancel the contracts, the current contracts. It says the central may pursue the invalidity and follow the cancellation procedure, and the Financial Monitoring Bureau will review the contracts, so it makes a kind of transparency. So and in addition for that, 141 of the article says of the constitution says the contract that they should be valid and until they are amended or annulled. And as we know, the Constitutional Court decisions are not retroactive, so they are cancelled in forward. So I can say, from my point of view, the current contracts are inactive, but we will see the central government's approach, whether they will review them or not. KRG make a statement, by the way. They say that oil and gas is not within the exclusive authority. Is this decision unconstitutional? And this federal government cut the Kurdish region's budget. And I am not making this production and export according to, does not need to make according to regional law, but the federal budget law of 2021, which says the North region has a right to produce 250,000 barrels of oil a day. So I based on that argument, I will continue my operations. So to conclude, I will say the constitution of the Iraq is not a strong central government, and it causes main problems. There is a public announcement share, and this federal budget law and also the other general principles of law, the KRG continues to operate its position. We will see the central government's approach for review and cancellation. But for stability for the investor and stakeholders, there should be a need for federal law. It's apparent. And by the time KRG also may enact a new regional law, not directly contradict with the constitutional provisions. So there's a constitutional issue. So the tribunals, when they are dealing with that, they should also be hesitant whether they have the authority to interpret, and whether this decision also does not cancel all the current contracts. So that's my part. Thank you very much for giving time. So I give the floor to you. Thank you very much for your kind attention. Regards.
Many thanks to Dr. Eskiörük for the presentation, and I would like to continue with our next speaker, Mr. Asad Mirzaliyev. Mr. Mirzaliyev is former judge of the Supreme Court of Azerbaijan Republic. He is arbitrator and deputy chairman of Azerbaijan International Commercial Arbitration Court under Azerbaijan Arbitration and Mediation Center. He is also honored lawyer of Azerbaijan Republic. His topic is Energy Legal Framework of Azerbaijan. We are ready to listen to you, Mr. Mirzaliyev. Excuse me.
Başlayayım. Hörmətli tədbir iştirakçıları, çox hörmətli arbitrlər. Hər birinizi Azərbaycan Beynəlxalq Kommersiya Arbitraj Məhkəməsi adından salamlayır, tədbirin təşkilatçılarına təşəkkürümü bildirirəm. Bugün mən sizlərə Azərbaycanda enerji sahəsində qanunvericilik bazası, onun yaranmasının tarixi anları, inkişafı və mövcud vəziyyət barədə məlumat verəcəyəm. Məlumat üçün bildirirəm ki, hər bir ölkədə səmərəli investisiya şəraiti yaradılmadan həmin ölkəyə xarici sərmayədarların, investorların cəlb olunması mümkünsüzdür.
Distinguished participants of the event, very respectable arbiters, I greet each of you on behalf of Azerbaijan Arbitration Court and would like to thank the organization of the event. Today, I would like to provide information on the legislative frame in the field of energy in Azerbaijan and also the history of its establishment, development, and current state. I would like to note that it is impossible to attract foreign investors to any country without creating favorable investment conditions.
Buna görə də 15 yanvar 1992-ci ildə Azərbaycanda xarici investisiyanın qorunması haqqında qanun qəbul edildi. Hansı ki, bu qanun Azərbaycan Respublikasının ərazisində xarici investisiya qoyuluşunun hüquqi və iqtisadi prinsiplərini müəyyən edir. Onun xalq təsərrüfatında xarici maddi və maliyyə ehtiyatlarının, qabaqcıl xarici texnikanın və texnologiyanın, idarəetmə təcrübəsinin cəlb olunmasına, bunlardan səmərəli istifadə edilməsinə yönəlmişdir və xarici investorların hüquqları müdafiəsinə təminat verir.
Therefore, the law on protection of foreign investment was adopted in 1992 in Azerbaijan. This law defines the legal and economic principles of foreign investments on the territory of the Republic of Azerbaijan. The law is aimed at attracting foreign material and financial resources, advanced foreign equipment and technology, management practices to the national economy, their efficient use, and guarantees the protection of the rights of foreign investors.
Respublikada belə qanunvericilik bazasının yaradılması, qısa müddət sonra əsrin müqaviləsi adını almış möhtəşəm müqavilənin bağlanmasına zəmin yarattı. 1994-cü il sentyabrın 20-sində Bakıdakı Gürcistan sarayında öz müstəsna əhəmiyyətinə görə əsrin müqaviləsi adını almış müqavilənin başlanması ilə ölkəmizdəki karbohidrogen ehtiyatlarının dünya bazarına çıxarmasının yeni dövrü başladı. Dənizin dərinliyi yerləşən çıraq, günəşli yataqlarının işlənməsi və hasilatın
Excuse me, Mr. Mirzaliyev, we couldn't hear you.
Əsrin müqaviləsində Türkiyə petrolları
Sorry, Sabira.
Kodiyevlə iştirak edirdi. Bu müqavilə sonradan 19 ölkəni təmsil edən 41 neft şirkəti ilə daha 26 sazişin imzalanmasına yol açdı. Bu sazişlərin imzalanması ölkəmizin neft sənayesindən gələn gəlirlərini artırdı və bugünkü inkişafımızın təməlini qoydu.
The establishment of such a legislative framework in the Republic paved the ground for concluding of a magnificent agreement called the Contract of the Century. So-called Contract of the Century, signed on September 20, 1994 at the Gülistan Palace in Baku, and gave a start to a new era of the export of Azerbaijan hydrocarbon resources to world markets. 8 countries like Azerbaijan, USA, Great Britain, Russia, Turkey, Norway, Japan, Saudi Arabia, and 13 companies, Amoca, BP, Dermont,
Düşüp bağlandınız, sesiniz kesildi.
Mikrofon, please mikrofon, Sabira. You listening me? Microphone.
Can you turn on your microphone, please?
Yes.
Asad müəllim, eşidirsiniz? Mikrofonunuzu yandırın, mikrofonunuzu yandırın.
Mikrofonu. Микрофон включите.
У нас микрофон.
Вот, сейчас вас слышу.
Do you hear us?
Yes, now yes.
Yes. So, and 13 companies like Amoca, BP, Dermot, Unocal, Sokar, Lukoil, Statoil, Exxon, Turkish Petroleum, Pennzoil, Itochu, Remco, Delta were part of the 400 pages contract of the century on the development and production sharing of such oil fields like Azeri, Chirag, and Gunashli located in the depths of the Caspian Sea. The agreement later led to the signing of another 26 more agreements with 41 oil companies from 90 countries. The signing of these agreements has resulted in the increase of the oil revenue in Azerbaijan, which is in its own turn created the ground for the country's current development.
Bu tarixi sənədin qəbulu ilə ölkəmizdə neft-qaz sənayesinin inkişafında yeni era başlandı. Həmin müqavilənin uğurlu icrasından sonra xarici sərmayədarlar tərəfindən Azərbaycana 10 milyardlarla dollar həcmində sərmayə qoyulmuşdur. Azərbaycanda hasilatın pay bölgüsü haqqında bağlanmış saziş, mülki hüquqi müqavilələrdən tamamilə fərqli bir sənəd olmaqla, onun qəbul və təsdiq olunması Azərbaycan Respublikasının Milli Məclisi tərəfindən qəbul edilmiş qanunla sənədləşdirilir. Və orada nəzərdə tutulur ki, sazişin qüvvədə olduğu müddət ərzində sazişə hökumət təminatına və əlavələrə uyğun gəlməyən və ya zidd olan Azərbaycan Respublikasının hər hansı başqa mövcud və ya qəbul oluna biləcək qanunlarının, fərmanlarının yaxud inzibati sərəncamların müddəalarından üstün hüququ və ya malikdir.
With the adoption of the historic document, era in the development of the oil and gas industry has begun in our country. As a result of successful implementation of this agreement, foreign investors have invested $10 billion in Azerbaijan. The production sharing agreement in Azerbaijan completely differs from civil law agreements. Its adoption and approval is envisioned by the law approved by the Milli Meclis Parliament of the Republic of Azerbaijan. While this law is in force, its provisions should be considered superior to the provisions of any other existing or acceptable in future laws, decrees, and or administrative orders of the Azerbaijan Republic in case they contradict or are non-compliant with the government guarantees and annexes of this agreement.
Həmin qanun qüvvəyə mindikdən sonra sazişdə nəzərdə tutulan konkret sahənin istənilən hissəsi barəsində əvvəllər bağlanmış hər hansı saziş, kontrakt və ya bu cür başqa sənədlə verilə bilən bütün digər hüquq və vəzifələr ləğv edilir. Qeyd olunan məzmunlu sazişlər Azərbaycanda enerji qanunverici sistemində əhəmiyyətli yer tutmuşdur.
Upon the entry into force of this law, the rights and obligations envisioned by any other previously concluded agreements, contract, or similar documents shall be terminated if they are stipulated in any part of the contract area of this agreement. The above-mentioned agreements have an important place in the system of energy legislation in Azerbaijan.
Daha sonra 3 aprel 98-ci ildə qəbul edilmiş elektroenergiyeti haqqında qanun, 30 iyun 98-ci ildə qəbul edilmiş qaz təhsili haqqında qanun, 24 noyabr 98-ci ildə energiyeti haqqında qanun, enerji resurslarından istifadə haqqında qanun, elektrik və istilik stansiyaları haqqında qanun, elektrik enerjisindən qazdan istifadəyə dair Azərbaycan Respublikasının Nazirlər Kabineti tərəfindən təsdiq edilmiş qaydalarla enerji sahəsindəki qanunvericilik təkmilləşdirilmişdir. Bu sahədə aparılan işlərin səmərəliliyinin artırılması məqsədi ilə 2 fevral 2009-cu ildə ixrac məqsədli neft-qaz fəaliyyətinə xüsusi iqtisadi rejimin tətbiqi haqqında qanun qəbul edilmişdir.
Furthermore, the law on electricity adopted on April 3, 1998, the law on gas supply adopted on June 30, 1998, the law on Enerji adopted on 24th November 1998, the law on use of energy resources and the law on electricity and power stations, as well as the law on the use of energy in Azerbaijan Republic and regulations approved by the Cabinet of Ministers of the Republic of Azerbaijan has improved the legislation in the field of energy. In order to increase the efficiency of work in this area, the law on the application of special economic regime for export-oriented oil and gas activities was adopted on February 2009.
Həmin qanunda xüsusi olaraq vurğulanmışdır ki, bu qanun Azərbaycan Respublikasının Milli Məclisi tərəfindən təsdiq edilmiş və həyata keçirməsinə icazə verilmiş Azərbaycan Respublikasının ərazisində, o cümlədən Xəzər dənizinin ona mənsub bölməsində xam neft və təbii qaz yataqlarının birgə işlənməsi və hasilatın pay bölgüsü haqqında sazişlər, boru kəməri haqqında və bu qəbildən olan digər saziş və qanunlar əsasında həyata keçirilən fəaliyyətə şamil edilmir. Bu qanun həmçinin Azərbaycan Respublikasının ərazisində, o cümlədən Xəzər dənizinin ona mənsub bölməsində olan yataqlarda neft-qaz əməliyyatlarının hər hansı biri ilə bağlı işlərin görülməsi, xidmətlərin göstərilməsi və ixrac əməliyyatlarının aparılmasına şamil edilmir.
This law specifically states that it is approved by Milli Meclis of the Republic of Azerbaijan and implemented on the territory of the Republic of Azerbaijan, and includes agreements on joint development of crude oil and natural gas fields and production sharing in the Caspian Sea, does not apply to activities carried out under the pipeline and other similar agreements and laws. This law also does not apply to the works implemented, services rendered, and import-export operations carried out which are related to any oil and gas operation in the territory of the Republic of Azerbaijan, including in the fields belonging to Azerbaijan Republic in the Caspian Sea.
Həmin qanunla müəyyən edilmişdir ki, podratçılar və subpodratçılar ixrac məqsədli neft-qaz fəaliyyəti ilə əlaqədar vergiləri bu qanunda nəzərdə tutulmuş qaydada və dərəcə ilə ödəyirlər. Eləcə də həmin qanunla müəyyən edilmişdir ki, podratçılar və subpodratçılar ixrac məqsədli neft-qaz fəaliyyəti ilə bağlı Azərbaycan Respublikasına idxal etdiyi, eləcə də Respublikadan ixrac etdiyi məhsullar və xidmətlərə görə gömrük rüsumundan, əlavə dəyər vergisindən azaddırlar.
This law also stipulates that contractors and subcontractors are exempt from custom duties and value-added tax for products and services imported into the Republic of Azerbaijan, as well as exported from the Republic in connection with export-oriented oil and gas activities.
Milli qanunvericidə neft-qaz məhsullarından elektrik enerjisindən istifadə qaydalarının pozulmasına görə cinayət məsuliyyəti və inzibati tənbih tədbirləri nəzərdə tutulmuşdur. Azərbaycan Respublikasının Konstitusiyasına görə qanunvericilik sisteminə daxil olan normativ hüquqi aktlar ilə Azərbaycan Respublikasının tərəfdar çıxdığı dövlətlərarası müqavilələr arasında ziddiyyətlər olarsa, beynəlxalq müqavilələr tətbiq edilir.
The national legislation envisions criminal liability and administrative penalties for violation of the rules on the use of oil and gas products and electricity. According to the Constitution of the Republic of Azerbaijan, if there is a conflict between the normative legal acts included in the legislative system of the Republic and interstate agreements to which the Republic of Azerbaijan is a party, international agreements shall be applied.
Hörmətli həmkarlar, Respublikamızın enerji sahəsində qəbul etdiyi qanunvericilik aktlarını sadalamaqla vaxtınızı almaq istəmirəm. Həm qanunvericilik bazasının və həm də məhkəmə sisteminin mükəmməl və güvənli olmasının sübutu kimi Azərbaycana xarici investorların günü-gündən artan maraqlarını, bu sahədə Azərbaycanda çox münbit şərait olmasını, ona görə də sərmayə qoymalarını göstərmək kifayətdir. 13 yanvar 2022-ci ildə təməli qoyulmuş dünyanın ilk hibrid tipli elektrik stansiyası, Qafqazın ən böyük külək elektrik stansiyası olan Xızı Abşeron Külək Enerji Stansiyası Səudiyyə Ərəbistanı Krallığının Asva Power şirkətinin vəsaiti ilə onların tərəfindən inşa ediləcəkdir.
Dear colleagues, I am not going to take your time by listing the legislative acts adopted by our Republic in the field of energy. as a proof that both the legal framework and the judiciary systems are perfect and reliable is the increase of foreign investment to Azerbaijan from day to day. On January 13, 2022, the start was given to the construction of the world's first hybrid-type power plant, Hızı Apşeron, which is called Wind Energy Station, which is the largest wind plant in the Caucasus, and which to be built by and at the account of aqua power of the Kingdom of Saudi Arabia.
Məlumat üçün bildirirəm ki, Azərbaycanda 1 sentyabr 2000-ci ildən 3 pilləli yeni məhkəmə sistemi fəaliyyətə başlamışdır. İşlərə baxılması birinci instansiya, apellyasiya və kassasiya mərhələlərindən keçir. Azərbaycan Respublikasında sahibkarlıq fəaliyyəti ilə əlaqədar mübahisələrə baxan birinci instansiya kimi kommersiya məhkəmələri, eləcə də apellyasiya və kassasiya instansiyası məhkəmələrində kommersiya kollegiyaları fəaliyyət göstərir. Qanunvericilik qaydasında təsbit olunmuşdur ki, kommersiya mübahisələri ilkin olaraq məcburi qaydada mediasiyada keçməlidir. Hər gəh mediasiyada mübahisənin həlli mümkün olmadıqda məhkəməyə müraciət olunur.
I would like to inform you that a new three-stage judicial system has been operating in Azerbaijan since September 1, 2000. The cases to be considered first go to the first instance, commercial court, then appeal and cassation stages. In the Republic of Azerbaijan, there are commercial courts as the first instance to consider disputes related to entrepreneurial activities. And there are also judicial boards on commercial disputes in the courts of appeal and cassation. The legislation of Azerbaijan Republic stipulates that commercial disputes are compulsorily subject first to mediation process. If it is impossible to resolve the dispute through the mediation process, then it should go to the court.
Son illər Azərbaycanda inkişaf etməkdə olan Mediasiya İnstitutunun neft-qaz sənaye sahəsində baş verən mübahisələrlə tətbiqini, mübahisələrin danışıq yolu ilə həllini daha məqbul hesab edirəm. Bu, uzun-uzadı məhkəmə çəkişmələrinin artmasının aradan qaldırar, mübahisənin daha tez və səmərəli həllinə zəmin yaradar. Mübahisənin həllinə mediasiya qaydasında nail olmaq mümkün olmazsa, o zaman arbitraj məhkəməsinə müraciəti məqbul hesab edirəm.
I believe it is more appropriate to settle all disputes in the oil and gas industry by the negotiations with the help of Mediation Institute, which has been developing in Azerbaijan in recent years. This eliminates the need for lengthy litigation and facilitates fast and more efficient settlement of disputes. If it is not possible to resolve the dispute through mediation process, then it is more appropriate to be considered by the arbitration court.
Məlumat üçün bildirirəm ki, beynəlxalq arbitraj haqqında Azərbaycan Respublikası qanununa və digər normativ aktlara uyğun olaraq 2002-ci ildə Azərbaycan Respublikasında beynəlxalq kommersiya arbitraj məhkəməsi təsis olunmuşdur. Keçən 20 il müddətində Azərbaycan Beynəlxalq Kommersiya Arbitraj Məhkəməsi öz fəaliyyətini genişləndirmiş, arbitraj və mediasiya sahəsində zəngin təcrübəyə malik Türkiyə, Almaniya, Rumıniya, Misir, Malaziya, Avstriya, Avstraliya, Birləşmiş Ərəb Əmirlikləri, İtaliya, Ukrayna daxil olmaqla ümumilikdə 10 ölkə ilə memorandum və ya qarşılıqlı əməkdaşlıq haqqında sazişlər bağlamışdır.
For your information, the International Commercial Arbitration Court was established in the Republic of Azerbaijan in 2002 in accordance with the law of the Republic of Azerbaijan on international arbitration and other regulations. Over the past 20 years, the Azerbaijan International Commercial Arbitration Court has expanded its activities and signed memorandums and/or mutual cooperation agreements with a total of 10 countries having extensive experience in arbitration and mediation, like Turkey, Germany, Romania, Egypt, Malaysia, Australia, Austria, the United Arab Emirates, Italy, and Ukraine.
Hazırda da bu sahədə fəaliyyətimizi genişlənməkdə davam edirik. Sonda bir daha vurğulamaq istəyirəm ki, Sizinlə qarşılıqlı əməkdaşlıq şəraitində çalışmağımızdan çox məmnunuq. Hesab edirik ki, bugünkü tədbir qarşılıqlı fəaliyyətimizdə öz müsbət təsirini göstərəcək və gələcəkdə bu sahədəki fəaliyyətimiz daha da səmərəli olacaqdır. Çox vacib və əhəmiyyətli çalışmalarınızda hər birinizə uğurlar arzulayıram.
The activities in this area keep going expanded. In conclusion, I would like to emphasize once again that we are very pleased to work with you in a spirit of mutual cooperation. We believe that today's event will have a positive impact on our collaboration, and our activities in this area will be even more efficient in the future. I wish each of you success in our very important and significant work. Thank you very much.
Thank you, Mr. Mirzaliyev. We hope so. I would like to continue with our next speaker, Mr. Cenk Pala. Dr. Cenk Pala is a permanent figure in both the Turkish energy security and the Southern Energy Corridor discussion in all respects, with vast industry experience in the Eurasian gas pipeline business. Currently, he is coordinating Ersan Oil refineries talks with potential partners, investors, and financial institutions. He is also an academician. We are listening to you for your presentation on new era for Caspian countries in supply diversification of Europe after Putin's war. Thank you.
Good afternoon to everyone. Hello to my Azeri kardeş and all hamınızı kucaklarım. I was a man who just worked for Azerbaijan for the last 25 years, for Vakıtübüs Ceyhan, for Shah Deniz, for Nabucco, then TANAP, then Trans-Adriatic Pipeline. I am here today to create the job for the arbitrators, because the new era, starting with Mr. Putin, who shuts himself from his, let's say, the leg, thanks to him, we are expecting more Azerbaijan, more Caspian gas via Turkey to Europe as a big, real substitute for the Russian gas. I'm not talking about a huge or in a just short of time, huge amounts, but I believe that with the help of Turkey and also Azerbaijan, we can open the way the other Caspian sources, especially for the Turkmen gas. So, but it was a dream once upon a time, especially the Caspian legal status is really that's a tough issue for all Caspian states. And there were a kind of nearly a war between Iran and Azerbaijan just because of Alov and Aros and Chark fields. And also it is the same for Turkmenistan. Two brothers about to have a kind of fight to each other for Güneşli, for Serdar Kepez field. Then in 2018, there is a kind of Caspian Convention just signed. But you know, it is signed, it says something, but I'm still confused about this, that is it really letting us to lay a pipe from Turkmenistan to Azerbaijan? I'm not sure. But afterwards, Azerbaijan and Turkmenistan just signed an agreement for Serdar Kepez field and changed the name of that field as Dostluk. And they have already started to lay the pipe from their part to their shores. So, in my opinion, this can be used as a kind of future Trans-Caspian pipeline system as soon as it's completed. I would like to just try to show some slides, if I may. I don't know. Yes, this one. I hope you are just seeing this. As you see from my first slides, it is German Chancellor, then today's Putin's worker, Mr. Schroeder, signs an agreement with Mr. Putin in 2005, September, which really bothers all of the former Soviet Union countries already joined to European Union as well. It is a magazine from Poland, from one of my students. It shows the shaking the hands for Nord Stream 2, Nord Stream as well. So everyone was happy. Only Turkey and Azerbaijan talking about the southern gas corridor, opening up a fourth corridor via Turkey to Europe, feeding Balkans, feeding Southeast Europe, feeding Central Europe. BOTAŞ, when I was a part of BOTAŞ, I was heading the today's international projects department in there. I was in everywhere, in every international projects in the kitchen, and the Germans just put me a nickname as a rabbit in the pipelines. So we started with Nabucco. Everyone ignores Turkey's importance, and also no one believes Azeri gas or Caspian gas or Middle Eastern gas via Turkey. Why? It is clear, because only stable country is only Azerbaijan, no way for Turkmen gas, no way for Iran, geopolitical reasons, and no way for Iraqi gas. And we already started with the Egyptian gas, Israeli gas, but they all stopped. We have only Azeri gas with us. Limited one, but we have. But at this time, the Europe continuously believing Russia and linking them with Russia and more Russia, let's say. It was really not easy for BOTAŞ and Turkey to talk about with the Europeans that we can open the way for Azeri gas and Caspian gas via Turkey to Europe. They were asking me why you are here in that meeting and talking about Caspian gas while we have a nice relations with the Russians. So we are getting gas from Russia and Norway and Algeria. What is your business with us? We don't want to bother Putin as well. Okay, this is why they ignore all projects developed by Turkey, like ITGI Poseidon, and also Nabucco pipeline, and the others. Then what happened in 2005, 2006 winter? There was a kind of gas cut to Ukraine. There's a kind of gas war between Ukraine and Russia. They just realized that they need a kind of new pipelines, maybe, but they again, ignore Turkey and Azerbaijan. But in 2009-10 winter time, it was a real gas war with Ukraine, and they just shut down, and all gas flow from the western line just cut off, and everyone just realized that they need a kind of big systems. But at the same time, when we started Nabucco project, Mr. Putin started South Stream project via Black Sea to Bulgaria. Then, because of the European regulations, Bulgaria is not allowed to do it with the Russians. And Mr. Putin just got crazy and turned back to Turkey. And as of 2014, in his visit to Erdogan, he declared that they changed the name of the South Stream project as Turk Stream. So they changed the name, they changed the route to Turkey. But their main aim is to bypass Ukraine in their Russian gas deliveries. They were using Yamal, but they would like to use mainly Nord Stream 1 and 2. Then they focused on Nord Stream 2, and they were somehow successful because they completed a Turk Stream project as well. I was the part of Turk Stream project. I was working for the government affairs for Gazprom. Because there is no offer from Azerbaijan and Turkey, Mr. Putin offered me a job. So I just have that permits for, let's say, the Turk Stream. But at the same time, they started with that Nord Stream stuff. Then, again, when you look at the picture, there is still, we have only TANAP on air. And it is very limited. And the capacity is 31 BCM, but now, today we are getting only 10 BCM on a little bit more from TANAP, and sending the gas via Trans-Adriatic pipeline to Italy as well. Limited, it's just 9 BCM right now. But TAP and TANAP can deliver 20 to 25 BCM easily. So in these new conditions, when you look at the, let's say, the picture in, like that, you can just see that we have the BOTAŞ system in there, we have TANAP, and we can deliver as Turkey as much as we can. But when you look at the picture today, European Union told that they would like to import gas mainly from United States as an LNG, and Mr. Biden promised them to send some 50 BCM. Today, there is a limited kind of capacity for LNG to Europe because the main regasification terminals are located in Portugal and Spain. And in the eastern part, there is nothing, only one or two, I don't know. So they have to increase the regasification capacity. At the same time, United States has to increase the shale gas production, plus construct pipelines, plus construct LNG liquefaction plants. So we are talking about at least 2 years' time to reach a real, let's say, the solution from US LNG. But we can utilize the long distance pipelines without adding more, let's say, the brand new pipelines by using Turkey-Azerbaijan connections. And as far as I know, the connection between Sangachal to Turkish-Georgia border, SCPX, they are planning to increase the capacity as of 2024 as 5 BCM more. Means today's TANAP capacity is 16 BCM. We can add up and increase the number to 21 BCM easily in 1 year time. But we can add up Turkmengas if we construct a pipeline from Caspian, from Turkmenbaşı to Sangachal, then we can increase the number to 31 BCM as well. The only construction is that 300 kilometers length of, let's say, the subsea passage of Caspian. The rest will be realized by adding some loops and increase the capacity from Sangachal to Turkey and Turkey to Turkish border to Greek border. Then it is easy to just a kind of less costly option to realize at least the Turkmen option. But for this case, we have to be sure about the Caspian legal status, and we don't know that what is the meaning of Caspian Convention with regard to subsea pipelines. Many experts just saying that Azerbaijan and Turkmenistan can do it as the two countries. But you know, there's Iran in there, and we are not sure about the Iran's position right now after Putin. Maybe they can be more Western, let's say, Westernize their voices, and maybe they can work with Azerbaijan and Turkey, and also the Armenians and the others with the South Caucasus. Then they can let Turkmens use their territories as well as to reach Turkey. But the main problem is in here that always be the Russians, I can say. I am not sure because in the convention, they already mentioned a kind of environmental impact assessment, which has to be approved by the all 5 littoral states. So this is not clear, and I have to be enlightened by someone. I am still waiting clarification. Could we trust Caspian Convention to lay the pipe between Turkmenistan and Azerbaijan or not? Or could we trust that to Dostluk field will be developed together, or lay a pipeline between Turkmenistan and Azerbaijan by using Dostluk field as well? With this Putin, this new type of Putin, I am not sure about this. He can do his everything, I think, to stop this Trans-Caspian passage, I think. But it also depends the Iranian positions, I can say. We believe that Azerbaijan's other fields will be in operation after 2027, 2030. We will be talking about more gas from Azerbaijan. But until that point, we can use other sources like Turkmen gas. For the first 5 to 7 years, we can use the TANAP system to reach Europe. And then if it is required, if Europe and United States put their hands under the stone and giving and finding some fund for Azerbaijan and Turkmenistan to lay a brand new pipeline, then we can just talk about a long pipeline system as well, a brand new one. from Turkmenistan to Azerbaijan to Turkey than to Europe, I can say. Otherwise, we know that Turkmenistan is a giant country for gas. They have 20 trillion cubic meters of gas, and they are not happy with working with the Russians. Russians already got all the Turkmen gas in 2003 agreement. Nearly two-thirds of Turkmen reserves has just signed by the Russians. But then they didn't pay the money to Turkmens. A kind of explosion, a kind of accident in there, and it is not worked as expected. And Turkmens lost the money with their Russian contract. And the Turkmens also lost money for their Chinese contract because China offered to pay not in dollars but in wheat. In kind, I can say, they would like to pay with the wheat to Turkmen. So they have no chance to open the way to Europe. And this time, if Europe is serious, if the world is serious, if they are really wanting to substitute the Russian, let's say the gas, southern gas corridors has to be effectively used with the help of and the coordination of Azerbaijan and Turkey. It has to be open to Turkmens as well. And I am sure that the Turkmens and Azeris also just keeping talks on that. We have already signed an agreement with Turkmenistan in 1998 for 30 BCM, 16 to Turkey, 14 to Europe. This is why the blue stream is equal to our Turkmen gas, 16, because Russians would like to cut down the Turkmen gas to Turkey. They realized that blue stream project with the same capacity of Turkmen agreement. And this is why BOTAŞ, my department, offered the OMV and the others, the Nabucco, with 31 BCM based on Turkey's Turkmen gas agreements. In that times, there is no kind of agreement between Azerbaijan and Turkey and Shah Deniz field. And afterwards, Azerbaijan just appeared as a new gas exporter as well, not only in oil. So this is why this is also a very bad news for the Turkmens at that time. But this time we can utilize together. It is a big opportunity to join the forces with our Caspian states. I am not excluding Uzbekistan as well, because Uzbeks can be, let's say, linked to the Turkmens only with 200 kilometers pipeline. Then you can also use the Uzbekistan gas and Turkmenistan gas. So this Trans-Caspian passage will be a kind of not only serving for the Turkmen gas, but also Uzbek gas. And you can also adopt the Kazakh gas if you want. You can also collect everything in Turkmenbaşı, then send it out to Sangaçal as well. But you know, this is the less costly option. You can just do it by just $5 to $6 billion by using those existing systems. Why I am just talking this? We can also utilize the BOTAŞ system. As far as I know, in the BOTAŞ system, there are some idle capacity, not less than 13, 14 BCM. This can be also utilized together with the TANAP, increase of the capacity. And the Western line, this line, is empty right now because Ukraine is bypassed and Turk Stream is started, and all deliveries to Turkey shifted from onshore to offshore Turk Stream 1 pipeline. So this one is empty, and this is reaching to Ukraine. And you can use this, some part of it in Romania. They are asking expensive tariffs, and this is Ukrainians' words. And Moldova, the usage right is with the Gazprom. But because of this war, European Union can have a decision in there by saying that empty Western line could be used as a reverse pipeline for the southern corridor deliveries from Azerbaijan and the Caspian, and just by changing the compressor station's place and also adding some loops or whatever, a kind of minor investment costs. I am just purely talking about existing pipeline system usage. So if you spare some 10 to 11, I don't know, maybe $10 billion would be enough to have a system from Turkmenbaşı to Ukraine. I'm talking about by using the existing pipelines as well. So there is a 14 BCM empty idle capacity in the Western line, and you can use BOTAŞ system, and also you can use the TANAP system to reach in here. Then you can reach Ukraine, and maybe you can reach afterwards Poland and the other countries like Czechia. So it will be a kind of increasing trade between European Union countries, and also you can also serve to Balkan region. So this is very simple, let's say, the thinkings of me. You are just seeing that it is two routes from Caspian, and also just via the Iran, having the Turkmenistan passage. But you know, especially the new arbitration, let's say the topics I am just talking about, if Russia says no for the Caspian legal status or the Caspian Convention, this is another arbitration for Azerbaijan with the Russia. And Iran can say something, but luckily, Iran have discovered something in Caspian Sea recently. So maybe Iran will be just working with in a cooperation with Azerbaijan and Turkmenistan in that sense. But you know, it is a politics. You can never be sure about this. So when you look at that picture as the final picture for my presentation as well, we have calculated some numbers. So if we really open the way, the Middle East and the Caspian sources, including Israel and the Iraqi gas, also Iranian and Qatari gas, because the United States will ask the help of Qatar as well. And if Iran sign an agreement for nuclear, then it can be treated as a green light from the United States, then they can be in the game of gas. So this is why I put everything, as this is all potential. Let's say the supply potentials to Turkey. When you look at this, Azerbaijan, Turkmenistan, Uzbekistan, Kazakhstan, you can aim nearly 60, 70 BCM from there, from Caspian, and nearly 30 to 40 BCM from Iran and Qatar. I would like to just remind you that if Qatar and Iran shake the hands for Pars field, one says south, one says north Pars, but the Pars field, total proved natural gas reserves in there is 51 trillion cubic meters. So 30 trillion cubic meters of Iranian gas plus 30 trillion cubic meters of Qatari gas reserves, you are reaching more than 300 trillion cubic meters of gas reserves only with Iran and Qatar. So I hope the Germany and France and the other, let's say, the cheating brothers of European Union just, you know, insist to diversify with the Southern Gas Corridor and the other sources, then the Russia, then Turkey and the Azerbaijan will be there to, you know, help and also support this idea. When you look at the picture, we are also seeing that Turkey has some 45-50 BCM LNG capacity in Turkey. We are constructing in Saros Bay, close to Thrace region, and we can only construct 200 kilometers length of pipelines from the existing BOTAŞ LNG terminal and also the under construction terminal to the border of Bulgaria, utilize the empty Western line as well. So we can also open the way for, let's say, the LNG as well. So we have more than 300 billion cubic meters of transit gas potential. And this can really make Turkey and Azerbaijan in the center of the European energy hubs. And we can serve together with Balkans as well. And Balkans need 19 BCM gas in a year, and there is no infrastructure in there. I am always saying in my old articles as well that SOCAR and BOTAŞ can make joint investments in Balkan area because they are all 100% dependent on the Russian gas. So this is why BOTAŞ and SOCAR can also work in Balkans and Southeastern Europe, I think. So my aim is to just show up with that potential. And also I know that it is not an easy way, but you know, it's you have to be prepared yourselves, and we have a tangible assets in our hands, and we can develop ideas for Europe, and this will be a very strong, let's say, the hand-to-hand business of Turkey and Azerbaijan, I believe. So I am just stopping here. If you have any questions, I am happy to answer. Thank you very much, everyone, for listening.
Thank you for this presentation, Mr. Pala. I would like to continue with Ms. Alida Mahmudova. Ms. Mahmudova is international lawyer with over 17 years extensive ADR practical experience. She is arbitrator and general secretary of Azerbaijan International Commercial Arbitration Court under Azerbaijan Arbitration and Mediation Center. Her topic is ADR mechanism available in energy dispute settlements. Thank you.
Thank you. Listen to me? Yes. Thank you. Firstly, I would like to say thanks EDAC, the Energy Dispute Arbitration Center, for organization of this webinar. Of course, our arbitration is created since 2003 as International Commercial Arbitration Court, and since 2008 it's reconstructed, and today it's Azerbaijan Arbitration and Mediation Center. Of course, we know specialization in energy area with a common arbitration, international commercial arbitration. In our experience, we haven't the energy disputes. Unfortunately, we have the majority of our cases is disputes which arising from the contracts, and the majority is the sale of goods. And for us, it's a very interesting experience, especially in disputes and energy sectors. Of course, Azerbaijan is one of the oil country, and we have the as before inform you about our legal framework in energy sectors by the Asad Mirzaliyev, and about our big contract on production sharing agreement. And of course, one of the main criteria of improving the business climate in the country, particularly in oil and gas sectors, is creating the favorable conditions for the use of, including using some possibility for using the alternative dispute resolution methods. In 2016, in our country, approved by the president decree, the strategic roadmap for the national economy in 11 main economic sectors. And one of the sectors is the area on small and medium businesses, where there's some instructions to improve and creations the alternative dispute settlement mechanism, improve the legislation on arbitration, both in international and national, because today, if we review our legislation on arbitration, we are focusing only the international arbitration, and we have the special law on international arbitration, which was adopted in 1999, based on UNCITRAL model law on international commercial arbitration. Of course, today need to the some requirements to revision this law, and maybe it will be in the future, and some inclusion of new provisions also regulated the national arbitration and eliminated in the current law on international arbitration some conflicting provisions provisions, contradictions provisions. There are some provisions which regulated the enforcement issue, because the enforcement of foreign arbitral awards is a very important part of the arbitration process. And in our legislation, and according to our legislation, is regulated by the Civil Procedure Code, and the Supreme Court of Azerbaijan Republic is a responsible body who's which is a party apply the applications to regarding the recognition and enforcement matters related to the foreign arbitral awards. This is a convention in force in Azerbaijan, entering in force in Azerbaijan since 2000. And you know that in 2000 also we established the new judicial system in Azerbaijan. And in addition, Azerbaijan also the party of the other international convention, like the European Convention on 1961 on international commercial arbitration, Washington Convention on settlement on investment dispute settlement, and of course we also have some disputes which settlement under the within the exit procedure. The international about when saying about the institutional aspects, as mentioned before, International Commercial Arbitration Court of Azerbaijan was established in 2003, and it is a single and only one permanent institute as legal entity in Azerbaijan. It's a common arbitration. We have the two lists, is a local arbiters list and the national arbiter list. Of course, now we working on improve, refresh, updated this list, both in local and international. And foreign arbiters, and also we working on revising our arbitration rules, because this arbitration rules adopted in 2003, and more time now, new challenges, and this is rules need to improving. Today, Azerbaijan Arbitration and Mediation Center has some cooperation relations with over 50 international arbitration institutes, including the EDACT. Last year, we signed the cooperation agreement with EDACT. We have the good relations with Italy, with Germany, Dubai International Arbitration Centers, and of course, we have some cooperation. We also, before the pandemic, we organized some international events in arbitration area, with Stockholm arbitrations, with Venice arbitration chambers in Baku, and we hope that this cooperations will be expand and will be in the future continue. Regarding the mediations, is other alternative disputes methods. It's a new institute in Azerbaijan. In 2019, adopted our new special law mediation. Also based on main principle of unilateral model law on mediation, and the European Commission on Efficiency of Justice guidelines. Yes, it is. This is mediation law regulated the dispute which is covered under the mediation. It's a civil, commercial, including the dispute with foreign elements, family, labor, and administrative disputes. But the family, labor, and commercial disputes is a mandatory requirements before they go to the court, need to pass the first informational session, mediation informational session. Because today's we propaganda for the small and medium entrepreneurships to use this is ADR methods because it's more effectiveness, and also we now we're working on revising of our arbitration rules and our charter of the international commercial arbitration, and we're also thinking about including some provisions before some hybrid procedure with mediation and arbitration. Before they go to the arbitration, we also some informational session and some proposed for use the mediation process. Today's a method of alternative dispute resolution in our country at not used maybe is no sufficient level, but we will try it because need to the more works on this area, which is following the directions of professional training of the staff, both in the field of arbitration and mediation. There's some also information for the populations about the using alternative effectiveness of the alternative dispute resolution methods, and of course expansions of the bilateral relations with the arbitration institute of other country, and maybe exchange was arbitrated in the list. For example, we now were thinking about including our foreign list of arbitrators is foreign arbiters, and also some specializations. For example, if the specializations of oil and gas sectors, of course, maybe in the future we request to them adapt in order to provide us such types of arbiters. That's all. Thank you for your attention. If you have some questions.
Thank you, Ms. Mahmudova. Last speaker of our webinar is Mr. Togrul Guluzada. Mr. Guluzada is an international lawyer and advocate at Azerbaijan Bar Association in the field of corporate investment and commercial business law. Also is an international arbitrator at London Court of International Arbitration and head of legal department at Azerbaijan Industrial Corporation. At the same time, he is lecturing law in various universities. His topic is place of Azerbaijan in energy arbitration. Thank you.
Well, thank you very much. I welcome everyone here. Thank you. Thanks to my colleagues from Turkey and Azerbaijan. And Azerbaijan colleagues, they gave enough information about regulatory framework of Azerbaijan Republic in energy law. And also thank you, Ms. Mahmudova also gave information about general overview of international arbitration in Azerbaijan. So I know you're tired. I'll try, and the time is limited, so I'll try to make it short and enjoyable. So the issue is now we know that we have three types of arbitration as a state, investment, and commercial. And if the question comes, which one Azerbaijan and which one is participating, I will say Azerbaijan participating in three of them. So in state arbitration, we have some proceedings which actually had already concluded in Permanent Court of Arbitration in Hague. For example, regarding status of Caspian Sea between Turkmenistan and Azerbaijan, that's well-known actually case. And also coming to commercial arbitration, yes, as Ms. Mahmudova also mentioned, we have International Court of Arbitration, and Azerbaijan parties, and Azerbaijan also acceded to convent to actually incorporated model law on international commercial arbitration, which is now part of our national law. And now actually the most important and interesting part, which is today is our topic, is energy arbitration. So in other words, I will call it investment arbitration. Azerbaijan actually has ratified several international legal instruments. So one of them mentioned again, I'm just repeating that in 1992, Azerbaijan acceded to Washington Convention on the settlement of investment disputes. We know this convention, Exit Convention is called also, and Azerbaijan also acceded to European Convention on Commercial Arbitration, and of course the one of the most important conventions, which is New York Convention on Recognition and Enforcement of Arbitrary Award. Yes, Azerbaijan is also party to this convention and applying the rules. And also briefly, of course, Mr. Mirzayev also mentioned, but I will briefly mention as well that in energy law, we have several most widely used legal acts. Law on use of energy, law on subsoil, law on gas supply. All these are legal acts which are widely used. And two basic actually regulatory regimes apply to oil and gas exploration. So, which actually gives right. There are two these regimes. One of them is established under the law on energy, which implemented through different energy contracts. And second is, as we know, also Mr. Mirzayev mentioned, we have production sharing agreements, which actually prevail over all laws and rules, except of course constitutional laws which adopted by referenda. So this PSA, I give abbreviation of this product share agreement. PSA actually, this PSA is define grant contractors the sole and exclusive rights to conduct upstream oil and gas operations in Azerbaijan. And this is a general regulatory framework. And the question is now the importance, the heart of the topic is dispute settlement. How is this dispute settlement actually is going on? So we all know we have ad hoc arbitration, we have institutional arbitration. Before going to this, also I would like to mention that Azerbaijan also has been concluding bilateral agreements with different countries, with various countries. And also Azerbaijan is party to multilateral conventions such as Energy Charter Treaty, and as I mentioned before, also Washington Convention. Why are those legal instruments important? Because in energy disputes, in PSA, product sharing agreements, we have generally accepted principles. Those principles are not compulsory, so they could be changed. But generally accepted principle means we usually in our PSAs, we refer to ancestral arbitration rules by choosing place of arbitration, in other words, ad hoc arbitration. Okay, but sometimes excluding, let's say, PSAs, we have other investment disputes, not like parties do not conclude PSA, but different energy contracts. Under those contracts, parties are free, and they usually choose and go to institution which both countries of those parties are party to those conventions, such as Energy Charter Treaty and Washington Convention. According to Washington Convention, they usually go to exit arbitration. But according to Energy Charter Treaties, they have choices, options again, ancestral rules, on the ad hoc arbitration, again, exit arbitration, so they can actually choose. Right now, we have in exit court, in exit arbitration, Azerbaijan actually has been party in 6 disputes. 2 of them actually, 2 of them pending, 4 of them concluded already. And by the way, 2 out of these 6 disputes, claimants are from Turkey. We have the name was the physical person, Cem Seljuk. I don't know who is that, but that's probably investor. And also we have Barmek company, they were delivering electricity, and those cases actually concluded. So, and those cases, disputes, actually were being proceeded on the exit arbitration rules. Having said all this, I would like also to mention that shareholders of companies, investors who are actually investing in Azerbaijan, they actually also have right to demand or claim for their loss independently. And what's the base for this? The base, the law on protection of investments in Azerbaijan, which allows shareholders to claim for their loss independently, which is actually unique because there's so too many contradictory issues about this in leading national law systems. But Azerbaijan actually provides this opportunity to shareholders as well. Well, having said all this, I want to conclude as our time is limited and you're tired. Thank you very much. If you have any questions, I'm ready to answer. Thank you.
Thank you to all speakers, and the presentation of our speakers have come to an end. Our participants can ask their questions if they wish. I guess there is no question for
Ben
now.
bir tek soru sormak istiyorum. I would like to ask a question to Tuğrul Bey maybe.
Yes, of course.
Do you know the details of that Caspian Convention? Is there any kind of right to Iran or Russia to kind of just voting against Turkmen and Azerbaijan deals like Dostluk and the pipelines?
Well, actually, what I know that because the arbitrator who actually was conducting this case was my professor in the Netherlands, and so I have information that the issue was about actually the status of Caspian Sea. It is sea or lake. Why? Because you know that sea and lake are divided differently. If it's a sea, and depending on the status of Caspian Sea, so international, let's say if we call it gives an international name, so oil resources and gas resources also could be in the area of Azerbaijan, or could be vice versa if it's lake. So that was a dispute, and what actually concluded that yes, Caspian actually should be considered as international sea. So that was the issue which I know mostly about this case. Yeah.
Okay. Thank you.
Thank you.
If there is no questions from our participants, I am terminating the session with your permission. Thank you to our speakers and our participants.
Thank you. Thank you very much, Aybican, and all participants. Thank you very much for all your contributions.